now into new BSA, Bharatiya, Sakshya, Adhiniyam. డాక్యుమెంట్ అన్న దాన్ని నిర్వచనం చాలా మార్పు తీసుకొచ్చారు డాక్యుమెంట్ అన్న దాని మీద. తర్వాత సాక్ష్యం ఎవిడెన్స్ అన్న పదాన్ని కూడా చాలా మార్పు తీసుకొచ్చారు. ఇప్పుడు కొత్త యాక్ట్లో, పాత యాక్ట్ ఇండియన్ ఎవిడెన్స్ యాక్ట్ నుంచి వెళ్ళి కొత్త యాక్ట్కి చాలా మార్పు తీసుకొచ్చారు. ఇప్పుడు ఏం మార్పు తీసుకొచ్చారంటే ద వర్డ్ డాక్యుమెంట్, ఇండియన్ ఎవిడెన్స్ యాక్ట్లో డాక్యుమెంట్ అంటే ఎనీథింగ్ రిటర్న్ ఆన్ ఏ పేపర్ డాక్యుమెంటే ఉండేది డెఫినేషన్ లోపల. ఇప్పుడు డాక్యుమెంట్ డెఫినేషన్ లోపల ఏం మార్పు తీసుకొచ్చారు? And you should not forget that Evidence Act is equally applicable to criminal cases as well as civil cases. Don't be under any impression that Evidence Act applies only to criminal cases. It equally applies to civil cases also. So, because of the provisions, certain provisions ranging from section 62 to 67, like that, this new act introduced extensive use of electronic evidence or rather electronic communications in the matter of admissibility of evidence in courts of law. For that reason only this definition was enlarged, rather expanded, rather more and more types of evidence was included in the definition of evidence and as well as the document. That is the reason behind this expansion in the definition of evidence and documents, and you will understand in course of time while I explain those provisions where electronic and digital evidence is extensively made use in this new act. And the reason behind this is, according to the lawmakers, that to encompass more and more types of electronic and digital evidence into the evidence admissible in courts of law, and also to minimize, to facilitate quick disposal of cases, to save time and to quick disposal of cases. That is the object behind making these amendments in Evidence Act, because this act is also very important for every one of us to know, because Evidence Act is like a heart to an individual. Without Evidence Act you cannot prove any case, civil or criminal, and one has to prove civil or criminal cases through evidence which is admissible, through evidence which is admissible in courts of law. To make the evidence admissible, one has to, the evidence that is going to be led must be in conformity with the Evidence Act, the present new Bharatiya, Sakshya, Adhiniyam. So keeping in mind these important changes and the object behind it, now let us examine the relevant portions of Indian Evidence Act which are important for us to know at this stage. Apart from section 1 which I have already disclosed, Jammu and Kashmir, the word Jammu and Kashmir is excluded and making it applicable to whole of India. That is one aspect. Applicability of this act even to court-martial proceedings taken under Indian Army Act, Naval Discipline Act and Air Force Act. Now the word document under section 21 small d, the word document now in the new act includes electronic or digital record, electronic and digital record in the form of emails, computer, laptop, smartphone, voicemail, stored in digital devices, So the word document is expanded, the definition of word document is expanded in section 2(1)(d) of BNS Acts, including electronic and digital record stored in laptops, emails, voicemails, smartphones and other electronic devices. So these are all called as documents, because one important change made in this Indian Evidence Act is under BSA is, unlike in Indian Evidence Act, the electronic record was secondary evidence in Indian Evidence Act. Electronic evidence or record, whatever it is treated as secondary evidence in Indian Evidence Act, whereas under BSA Act, the electronic and digital evidence is given the status of primary evidence. Is given status of primary evidence. Now it is no more secondary evidence under the new Act. Under the new Act called as BSA, it is primary evidence. Primary evidence means it has got equal value, legality like any other primary evidence, like any other document. No, certificate is also there. The issuance of certificates along with the digital evidence or electronic evidence or digital record is not dispensed with that under the new Act. Even under the new Act also, certificate is necessary, and that certificate, a separate pro forma is given for that certificate, which you will find immediately after the last section, that is section 170. 170 తదుపరి ఆ సర్టిఫికేట్ ప్రోఫార్మా కూడా మీకు బుక్లో ఇచ్చారు. ఇందులో ఆ సర్టిఫికెట్లో ఏమి ఇచ్చారంటే చాలా డీటెయిల్స్ ఫర్నిష్ చేయాలి. అన్లైక్ 65B సర్టిఫికేట్ చాలా డీటెయిల్స్ ఉన్నాయి అందులో. అందులో హ్యాష్ నెంబర్, హ్యాష్ వాల్యూ అవన్నీ కూడా మెన్షన్ చేయాలి. అండ్ సపరేట్ ప్రోఫార్మా ఈజ్ దేర్. యూ విల్ ఫైండ్ దట్ ప్రోఫార్మా ఇమ్మీడియట్లీ ఆఫ్టర్ సెక్షన్ 170 ఇన్ ది న్యూ యాక్ట్. న్యూ యాక్ట్లో క్లియర్గా సపరేట్ ప్రోఫార్మా ఇచ్చారు. ఆ ప్రోఫార్మాలో ఏమన్నారంటే whenever this type of evidence is produced at each stage of admission, the certificate has to be furnished. It has to follow with the certificate. That is the. So when I come to section 64, 63, I will explain that. But for the present, it is suffice for us to know that unlike in Indian Evidence Act, which is secondary evidence, now under the new Act, it is primary evidence. It is primary evidence having the same legality, same admissibility, same value as that of primary evidence. So that is the change, that is the important change brought out in the BSA from the earlier Indian Evidence Act. So the word document, the definition of document under section 2(1)(d) of BSA Act expands the definition, including the electronic and digital records stored in not only certain what you call previously iPad లో ఉండేది సప్లైడ్ బై గవర్నమెంట్. ఇప్పుడు దాన్ని ఎట్లా ఇంక్లూడ్ చేశారంటే ఈవెన్ ఇట్ ఈస్ కంటైన్డ్ ఇన్ ది ల్యాప్టాప్ an individual, stored in the laptop an individual, stored in the smartphone of an individual, stored in the shape of a voicemail, email and so on and so forth. So the word definition of document is expanded under section 2(1)(d). Similarly, under section 2(1)(e), the definition of evidence is also expanded and included. Information given electronically also is included in the evidence. ఎలక్ట్రానికల్లీ ఇన్ఫర్మేషన్ ఇచ్చింది కూడా ఎవిడెన్స్ కింద ట్రీట్ చేశారు. దీనివల్లనే సెక్షన్ 530 కింద BNSS యాక్ట్ కింద ఏమన్నారు, ది ఎవిడెన్స్ ఆఫ్ విట్నెసెస్ కెన్ బి రికార్డెడ్ ఎలక్ట్రానికల్లీ. The accused can be examined or charges can be framed against accused electronically. The arguments can be heard, the final reports can be filed under section 210 of BNSS Act electronically. The cognizance can also be taken electronically. So to cope up with, to go in terms with the amendments made in the BNSS Act, these amendments were brought out in the Evidence Act. Because as you all know, unless Evidence Act permits, any kind of evidence is not admissible in courts. Every evidence, either oral or documentary, secondary or primary evidence, it has to be in conformity with the provisions of the Indian Evidence Act. Now BSA. Unless it fit into the terms of this BSA Act, no evidence can be is admissible. So in order to make that electronic examination, online presentation of charge sheet, online examination of accused, online examination of witnesses, all this to make that amendments in BNSS Act to come into force, these amendments were brought out in BSA Act. So this is 2(1)(e) lo kuda evidence annadi any information given electronically is treated as evidence. Not only the direct evidence, that is oral evidence. In addition to oral evidence, now the witness need not be present before the court. The accused need not be present before court for facing charges. They can be done by electronic audio-video means. Audio-video means. To make that applicable or rather permissible, these amendments are brought out in section 2(1)(e) of BSA Act in the word evidence. Now similarly, now under section 6 of Indian Evidence Act, we have a provision called facts though not in issue are so connected with fact in issue being part of same transaction is relevant. That is popularly known as the principle of res gestae. Now under new Act section 4, apart from facts though not in issue, now what section 4 says, facts though not issue are so connected with relevant fact forming part of same transaction is relevant. Section 4 lo, adi section 6 Indian Evidence Act, section 4 of BSA Act. The only difference is relevant fact అని ఇక్కడ అన్నారు, అక్కడ fact in issue అన్నారు. అంతకుమించి తేడా ఏం లేదు. So this is the change we have to understand. What is the change in from section 6 to section 4 of BSA Act. Now another section is, we all know section 24 to 27, they deal with Indian Evidence Act. Section 24 to 27, they deal with admissibility of confession and recovery. Admissibility of confession and recovery. Section 24, confession procured by inducement, threat or promise not admissible. 25, a confession made to police officer not admissible. Confession made while in the custody of police, section 26 not admissible. 27, confession leading to discovery of a fact, so much of such information, whether it amounts to confession or not, is admissible. 27 is an exception to section 24 to 26. Now all these sections are made into 3 sections only. Now section 24 holds Indian Evidence Act. Now section 22 lo ఏమన్నారు, section 24 Evidence Act లో confession procured through inducement, threat or promise is not admissible. Section 22 లో ఏమన్నారంటే ఈ 3 సెక్షన్లకు inducement, threat, promise ఈ 3 వర్డ్స్ అట్లాగే ఉంచి అనదర్ వర్డ్ coercion is also included in section 22. అంటే ఇప్పుడు సెక్షన్ 22ని మనం పాత సెక్షన్ 24, ఇప్పుడు కొత్త సెక్షన్ 22ని మనం ఏ విధంగా చదవాలంటే, Confession procured through inducement, threat, promise or coercion is inadmissible in evidence. కొత్త section 22 of BSA Act ప్రకారం. అండి? Yes, yes. So, this is the only change in the new Act, BSA Act. Now, another important is section 24. మనము section 24 Indian Evidence Act లో section 30 confession of co-accused facing same trial is admissible against the other accused అన్నట్టు. The section 24 of BSA Act says provides for a provision for joint trial. Joint trial అంటే ఇక్కడ section 24 BSA Act లో ఏమన్నారంటే where more than one accused are facing trial and in the middle one of the accused flees from the judicial purview and not available to face trial. In such cases under section 24 it has to be treated as a joint trial and the confession of that one accused is admissible to against the accused who is not before the court, who is absconding. Section 24 కొత్త యాక్ట్లో ఏమన్నారంటే where more than one accused is facing trial for a single offence or similar offences. During the course of trial, if one of the accused flees and not available for facing trial, such trial shall be treated as a joint trial and without his presence, like proclaimed offender under section 356 of BNSS Act. So, ఇక్కడ ఏమన్నారంటే సెక్షన్ 24 కింద జాయింట్ ట్రయల్ కిందనే ట్రీట్ చేసి ట్రయల్ కెన్ బి కంక్లూడెడ్ ఇన్ హిజ్ అబ్సెన్స్. దట్ ఈస్ ది purport of. So, evidence recorded in that trial will be treated as evidence against the fleeing accused person and it shall be treated as a joint trial, irrespective of the fact that one of the accused is not before the court. That is the purport of section 24 of BSA Act. Now another section, section 32 of BSA Act. This is another important change. It says that if any electronic and any book is published in electronic and digital form under the authority of government, it shall be treated as a book published by such government and it is admissible in evidence. సో అంతకుముందు ఓన్లీ డాక్యుమెంటరీ ఎవిడెన్సే ఉండేది. ఇప్పుడు ఎలక్ట్రానిక్ డిజిటల్ ఫామ్లో కూడా ఏదన్నా బుక్ పబ్లిష్ అయితే అండర్ ది అథారిటీ ఆఫ్ ది గవర్నమెంట్ కనుక పబ్లిష్ అయితే సచ్ బుక్ ఇన్ ది ఎలక్ట్రానిక్ ఫామ్ ఆర్ డిజిటల్ ఫామ్ పబ్లిష్డ్ ఆన్ బిహాఫ్ ఆఫ్ ది గవర్నమెంట్ షెల్ బి అడ్మిసిబుల్ యాజ్ దట్ ఆఫ్ పబ్లిష్డ్ బై ది పర్టికులర్ గవర్నమెంట్. సో దిస్ ఈజ్ ది ఎవిడెన్షియరీ వాల్యూ అటాచ్డ్ టు a book published in digital and electronic form. So why in the beginning itself I told you that Evidence Act morely concentrated on giving evidentiary value as that of a primary evidentiary value to documents which are in the electronic and digital form. So to meet that requirement only this 32 section 32 is provided in BSA Act. Now another important section is section 39 which corresponds to section 45 of Indian Evidence Act. Section 39 of BSA is corresponding to section 45 of Indian Evidence Act. You all know what is section 45? Expert evidence. What section 45 provides, whenever a court has to form an opinion upon a foreign law, art or science, the opinion of persons who are well educated in that art or science is relevant. That is section 45 of Evidence Act. Now under the section 39 of Indian Evidence Act, keeping those persons intact, expert having knowledge, having expertise in foreign law, art or science any method. Now, any expert in any other field, the word expert in any other field is included in this new section 39. That means the scope of the persons who are called as experts and whose evidence is admissible under the old section 45 of Indian Evidence Act. Now in section 39 of new Indian Evidence, BSA, Bharatiya, Sakshya, Adhiniyam, the scope is expanded including any other expert in any other field, maybe in other field also, not only in the field of foreign law, foreign science or foreign art. ఇప్పుడు ఏమైంది, ఇంకా దాని పరిమాణాన్ని ఇంకా పెంచారు, ఇంకా కొత్త ఎనీ అదర్ ఎక్స్పర్ట్ ఎనీ అదర్ ఫీల్డ్ అని సెక్షన్ 39లో, which is corresponding to section 45 of Indian Evidence Act, those words are used in this new section 39. That is the important change one has to make note. Now under the section 53 of BSA, section 53, now oral evidence given electronically in electronic mode is also given same legal effect as that of primary evidence. అంటే కోర్టు ముందుకు వచ్చి చెప్పకుండా ఎలక్ట్రానిక్ మోడ్లో ఇచ్చిన సాక్ష్యం ఓరల్ ఎవిడెన్స్ కూడా it will have the same legal effect as that of a oral evidence given on oath before appearing before court. So in the beginning itself I have told you that under BSA new act, the electronic and digital record and electronic evidence are evidence given electronically are now primary evidence. They are not secondary evidence, they are now primary evidence. That is the reason why these changes are made in the BSA Act. Even oral evidence given by a witness in electronic mode or audio video means will have the same effect as legal effect as that of primary evidence, as that of oral evidence given before a court of law. That is the purport of section 53. Now section 57 and section 85 of BSA Act. Section 57 and 85 of section 57 of BS Act, not 85, section 57 of BS Act. This is very important for us to know. 57, 63 and 64, 62. These are the four important sections that will make us understand about the admissibility of electronic and digital evidence in the court of law. So what section 57 of BS Act says, any electronic or digital record shall be treated as original and primary evidence, and 57 has given four categories of evidence, digital and electronic record. The first category is where an electronic or digital record is created or stored simultaneously and sequentially in multiple files, stored in multiple files. Each such of file is treated as original and primary evidence. If electronic information or digital evidence is recorded in different files, multiple files, either simultaneously or sequentially, one by one after the other. Now what section 57 says is, each of such electronic and digital record is an original and primary evidence. And another clause is where the electronic and digital record is produced from proper custody, Such evidence shall be treated as primary and original record evidence unless it is disputed. Unless it is disputed. And ఇక్కడ two types of safeguard is provided. One safeguard is provided to state, another safeguard is provided to accused. What section 54, explanation 5 to section 57, explanation 5 to section 57 provides that whenever electronic or digital record is produced before a court of law, such evidence shall be treated as original and primary evidence unless it is disputed. Dispute చేయకపోతే it has to be accepted as evidence, it has to be accepted as proven fact. That is explanation 5 to section 57. And another category is where a video recording is simultaneously stored in electronic form, or transmitted to another electronic device, or broadcasted or then each of such transmitted electronic record or stored record shall be treated as original and primary evidence under section 57 of the Indian BSA Act. And another category is where electronic or digital record is stored in multiple storage spaces in a computer. Where electronic or digital record is stored in a multiple space storages in a computer, each of such electronic record shall be treated as original and primary evidence. So now with this section 57, the scope of electronic record and types of electronic record and digital record which are admissible in court of law are clearly explained. Now at this stage I will pause and I will refer to two sections which will create a danger of tampered and manipulated evidence being brought on record in a court of law, and endangering and invading into the privacy of an individual. Now already I have told you under section 94 of BNSS Act, section 94 of Bharatiya Nagarik Suraksha Sanhita Act, a power is given to court to summon any person, any document which is necessary for investigation as evidence, including digital evidence, and magistrate is also having power under section 94 of BNS Act to order for search and seizure of electronic device from any person even though he is not an accused. Now let us examine a scenario where a magistrate orders for search and seizure of an electronic device from one of you or from me, take it from me. If he orders my cell phone to be seized, what will happen to my privacy? Though I am not an accused, though I am not connected with the crime, but still some information is laid before the magistrate that my cell phone contains some evidence which may throw some light on in the investigation, which is helpful in the investigation, and my cell phone is seized. What will happen to my privacy? Who will give me guarantee that my cell phone will be stored in a safe and secured place without affecting my personal information being divulged to others? Who will give this guarantee? Is it not invading into privacy of an individual? So to make electronic evidence admissible, such powers are given to magistrates under section 94 and similarly under section 185 of BNSS Act. The power is given to police office to search and seize any electronic device of any person not connected to the crime also, if he has reason to believe that such electronic device is having evidence which will help him in the course of his investigation. The police officer has given powers under section 185 of BNSS Act. If he comes and seizes my laptop, nowadays these electronic gadgets are part of everyone's life. Without using them we cannot live. Even the children are habituated to use these electronic gadgets. Instead of learning lessons, they are watching Chota Bheem, Bada Bheem, like that. So what will happen to the privacy of an individual, which is guaranteed under the Indian Constitution, which is not at my whims and fancy, which is guaranteed. The lawmakers have not taken note of all these eventualities, of all these shortcomings, or all these ill effects of these new laws. So why I have mentioned these to make you understand what is the danger that is going to be faced by individual, not only accused, even individuals also. So section 57 is this. Now section 58 of BSA Act, another important amendment in BSA Act, is expansion of secondary evidence. Under 63 of Evidence Act, if I am correct, section 63 of Evidence Act, the secondary evidence is, what are the secondary evidence? Certified copies, copies made from a mechanical process, and writings on the sculptures. Each such stone is a వాటికి ఇంకా ఇప్పుడు ఏం చేశారంటే యాడ్ చేశారు ఏమని, oral as well as written admissions made by a party. Now they have become secondary evidence, expanding the definition of secondary evidence as contained in section 63 of Evidence Act. Now under section 58 of corresponding to section 63 of Indian Evidence Act, section 58 of BSA Act expands the definition and includes oral and written admissions of a party. And the testimony of a person who has examined a document and given opinion on that document. Testimony of a person who has examined a document and given opinion on that document is also included in the definition of or category of secondary evidence under section 58 of BSA Act. This is another important change in the Indian Evidence Act, in the BSA Act, corresponding to old Act. Now sections. I invite Sri Kolisatharana Garu, member Bar Council of State of Telangana, and I invite, and I feel immensely happy that he is present today to bless me. Now section 61 of BSA, Bharatiya Sakshya Adhiniyam, provides that electronic or digital record will have same legal effect, validity and enforceability as any other document. So it will have the same validity, legal effect and enforceability as any other document, because already I told you now electronic and digital record is considered as a primary evidence. Now section 62, what section 62 of Bharatiya Sakshya Adhiniyam says, that contents of electronic records, contents of electronic or digital records may be proved in accordance with section 63 of the Act. May be proved according to section 63 of the Act. Evidence Act lo kuda section 64 undi. Emunde contents of electronic record shall be proved as in accordance with section 65B of Evidence Act etla undo అలాంటి ప్రొవిజనే ఇది. ఏమంటే సెక్షన్ 62 ఏముంటుందంటే కంటెంట్స్ ఆఫ్ ఎలక్ట్రానిక్ రికార్డ్ మే బి ప్రూవ్డ్ ఇన్ అకార్డెన్స్ విత్ సెక్షన్ 63. సో దట్ ఈస్ పర్పస్ ఆఫ్ సెక్షన్ 62. నౌ లెట్ us 65B. Now let us come to the important section, section 63. Now section 63 lo, apart from original section 65 lo ఏముండేది, any information stored in electronic and magnetic media supported by certificate is admissible. In addition to that, another important another device is made, another in any electronic information, digital information is recorded in semiconductor form. Apart from magnetic and electronic media, semiconductor form lo kuda store in electronic and digital device kuda, in addition to optical and magnetic media as provided under Indian Evidence Act, any information digitally or electronically recorded in semiconductor form is also forming part of electronic evidence. This is one part of section 63. Now another part of section 63 subclass 4. Section 63 subclass 4 provides that a specified certificate, a certificate specified pro forma shall be accompanied with electronic evidence at each stage of its admission. And a specified form of certificate shall be accompanied with electronic evidence whenever such electronic evidence is produced before a court of law. Rejected. 64(3). Now this specific form is, I already told you, it is available in the book itself immediately after section 170. If you open the book after 170, you will find that specific format of certificate that has to be given by the person authorized to give such certificates. I think anybody has got that book? It is there now? So after section 170, that pro forma is given. If you understand that pro forma and if you print that pro forma in your mind, it will be useful for you to counter the certificate produced by the investigating agency. If that certificate is not in conformity with that pro forma, you can raise objection for marking that up, but admitting that electronic evidence. Okay? Before that, under 65B, a certificate was given in different formats, and affidavit is sufficient under. And you all know the development of law laid down by Supreme Court in 4 important judgments. You all know, one judgment says it is mandatory, another judgment says it is not mandatory, another judgment says if it is difficult for a person to produce 65 certificate, not necessary. The latest judgment of Supreme Court says that under all circumstances it is mandatory. That is the, now that judgment is not disturbed till today. Now under this present section 63, now it says that each electronic evidence, whenever it is produced at each stage of admission, it has to be followed by a certificate specified pro forma made provided in the Act. That is another thing. And another important change from Indian Evidence Act to the present BSA is now under 65B of Indian Evidence Act, the certificate is to be given by a responsible person having authority, having control over the electronic device from where it is copied or whatever it is. Now this section 63 says if any person in charge of the computer, any person in charge of the computer or communication device, any person who is in charge of the computer or communication device or management of the events of from the device, or an expert can also sign the certificate. Expert also can sign the certificate. Now that is the subtle change made from section 65 Evidence Act to present section 63 of BSA, Bharatiya, Sakshya, Adhiniyam. So this is the change in the. So this is all about admissibility of electronic and digital record now under this new act. Now by this you might have understood what is the object behind these changes and what is the importance of these changes and what is the use and misuse of these changes. Use is it is apparent in section, but what about misuses? So there is every possibility of tampering and manipulating the electronic record. One cannot guarantee that electronic record which is produced in the court of law is not tampered or not manipulated, because one electronic evidence may pass through hands. Suppose if there is any what you call in social media, if somebody posted a certain posting which constitutes an offence, and that is the primary receiver, rather the generator, and that individual transmitted them to 30 friends and so on and so forth, and which record he will produce investigating officer? Where is the guarantee that there is no tampering and manipulation taken place at the hands of intermediaries? There is no safeguard provided in the new act. And like I said before, section 84 and section 185 of BNSS Act provides powers to court to search and seize an electronic device from any individual even he is not connected with the crime. And section 185 gives power to investigating officer to search and seize any electronic device from any person if he has reason to believe that such electronic device contains some information which is helpful to him in the investigation. He may seize that electronic device, and there is no guarantee under whose custody, under what circumstances, and that device will be stored or kept. And there is no guarantee that any other information, because in laptop one individual may store so much of information regarding his family, friends and other things also. Then he is not entering into private life of an individual, and there is no guarantee in what shape it will be preserved and when it will be given to me. And these are the shortcomings in the amendments brought out in BSA Act, which the lawmakers have completely forgotten to take note of it. No, they should have foreseen all these difficulties and all these shortcomings before they make a law. But it is very unfortunate that opposition have been suspended from the House, and no stakeholders were consulted. Stakeholders means advocates, advocate associations, bar councils, Bar Council of India, legal luminaries, juries, and other eminent law lecturers and professors. Nobody was consulted. As I told you in the beginning, The standing committee has spent a quality time for discussing these amendments, these new acts is just 43 hours 34 seconds. It is very unfortunate. So these are the few amendments, and coming to another amendment is section 80 of BSA Act. Section 80 of BSA is almost equivalent to section 90 of Indian Evidence Act. Section 90 provides presumption as to genuineness of a document of 30 years old. It is on similar lines. Section 80 is on similar lines, no exactly on same lines, it is on similar lines. What section 80 of BSA says, that the court shall presume the genuineness of every document purporting to be the official gazette genuine గా ట్రీట్ చేయాలి. ఇక్కడ వరకు బాగానే ఉంది. నెక్స్ట్ ఏమన్నా చూడండి, ది న్యూస్ పేపర్, ద జర్నల్ and every document purporting to be a document directed by any law to be kept in any particular form, and if the document is substantially kept in that particular form, shall be treated as a genuine document and admissible in evidence. Official gazette అంటే it's no problem, it has to be official gazette. Even in Indian Evidence Act also there is a section about the admissibility and treating the same as genuine, because of it is the gazette issued by a government established by law. What about newspapers? ఇప్పటిదాకా మనం సుప్రీంకోర్టు జడ్జ్మెంట్స్, హైకోర్టు జడ్జ్మెంట్స్ చదువుకున్న జడ్జ్మెంట్స్లో ఏమున్నాయండి? న్యూస్ పేపర్ ఈజ్ నాట్ అడ్మిసిబుల్ అని ఉన్నాయి. జర్నల్స్ కూడా అడ్మిసిబుల్ కాదు. ఇప్పుడు న్యూస్ పేపర్, జర్నల్ కూడా నౌ దే ఆర్, బికాస్ దే ఆర్ ప్రింటెడ్ ఇన్ ఎలక్ట్రానిక్ మోడ్. ఎలక్ట్రానిక్ న్యూస్ పేపర్స్ కూడా ఉన్నాయి కదా, ఇప్పుడు అవన్నీ కూడా జెన్యూన్ అని ప్రిజ్యూమ్ చేయాలని సెక్షన్ 80 చెప్తుంది. Now see the difficulty one will face in the court of law. If some news editor or a news agent or a stinger or whoever he may be purposefully provides a false and a fake news and it is published in the newspaper, now as per section 80 it shall be treated as genuine. What will happen to the fate of an accused? How we are going to defend our client? Now, I am sure all this will go into legal scrutiny before Supreme Court, before High Court, and we have to suffer for at least 2 to 3 years to get the interpretation on these draconian provisions. In some of the draconian provisions, I don't say every act is a draconian law, but some of the provisions are like that, like section 80. And another section is section 85 and 86. 85 and 86 of BSA. BSA means Bharatiya, Sakshya, Adhiniyam 2023. These two sections provide admissibility of digital signature of a person who is not available in India. ఇప్పుడు digital signature కూడా now under section 85 and 86 that signature is admissible. అంతకుముందు electronic signature ఉండేది. Under Indian Evidence Act previously electronic signature was admissible under Indian Evidence Act, but under this new act even digital signature is also admissible in evidence. Another important section is section 136 of BSA Act, 138. Now under Indian Evidence Act, under section 133 of Indian Evidence Act, testimony of an accomplice is admissible for convicting a person if it is proceeded upon the uncorroborated testimony of 133 Evidence Act lo uncorroborated testimony of accomplice is admissible against the other accused. Now under 138 of BSA Act, the word uncorroborated testimony is excluded, omitted. The word uncorroborated testimony is omitted, and the word corroborated testimony is included. Corroborated testimony is included. That is, now if the testimony of an accomplice is to be admitted in evidence, it must be corroborated from other sources. Unless it is corroborated from other sources, such testimony is not admissible in evidence. That is the another major change from old Indian Evidence Act to new BSA Act. Now, these are the main changes in BSA from Indian Evidence Act. And now I already told you that lot of thrust was given to admitting the electronic and digital record in course of admitting the evidence in the courts. Previously, this was not there. This was only available under section 65 for limited purpose. Now we have got provisions like any other BSA Act to examine the witnesses electronically in audio video device, means to examine the accused, to frame charges against the accused in audio video, means to record the evidence of witnesses who are unable to come before the court because of their old age and illness, and to record to hear the arguments and to pronounce the judgments, to receive the final reports from police, and all these things are in electronic means and audio video means. That is so to keep pace with the amendments made in BSA Act of examining the accused audio video means, examine the witnesses in audio video means, receiving. So to keep pace with those amendments, these amendments were brought in BSA Act. Now these amendments, some amendments I already told you, they come in a long way in minimizing the trial process, but at the same time they are very hazardous and dangerous to the life and liberty of an individual, including the accused. And so these are the few important changes in the BSA Act, and if anybody is having any doubt, you may ask me. I try to explain.